So can I just start by actually acknowledging the unsung heroes of these CyCon events, which is the CCDCOE staff, including Anne, and I'd appreciate it if we can all clap. It is in the context of that book that I've had a privilege of actually working with Anne very closely, and it is in that context I can affirm that she's a brilliant person, and it's been a delight to work with her on the book, and so I wanted to say that at one point or another. I'll also tell you that in person later. Okay, so as was said, we're here to talk about fair and proportionate data processing in the context of military operations. And I think I didn't choose the title. The title was chosen by CCDCOE. And I think the title is intentionally provocative and aimed to be triggering. It's triggering for me, at least, because of those two words, fair and proportionate. Anyone who's interested in data protection would know that the word fair usually evokes the FIPS, those set of fair information processing, also including security processing standards that was developed by the NIST in the United States. Whereas proportionate, for most of us, would evoke European standards, namely the European Court of Human Rights standards around the collection of intelligence in the context of the right to privacy under the European Convention, or say the GDPR, the General Data Protection Regulations, proportionality obligations. And so we have here the intersectionality of data protection norms from two sides of the continent, and I think that that is a good segue into what will be the context of our discussions, which is the way militaries who are engaging heavily in data-intensive practices might be bound by certain of these norms. That would be the scope of all I'll say today, okay? Because the real reason you're here is to listen to these three brilliant individuals who will each share a presentation with you. And we'll go in the order, and I'll introduce them one by one as we go along, starting with Sebastian. So Sebastian Cymutta is seconded by the German Armed Forces to the NATO CCDCOE as a law researcher. He studied law at the University of Munster, Germany, and Tartu, Estonia. Before joining the German Armed Forces as a litigator in 2015, he worked as a legal advisor at the German Aerospace Center. At the CCDCOE Center, he focuses on the application of the international law to the cyber operations, as well as questions of data and information sharing in the military context. All right, so the way we're going to do it is that each of them is going to talk for about 15 minutes on a topic that they've prepared. That will leave us sufficient time for Q&A with the audience. I'm not going to abuse my rights as a moderator. I'll leave it to your questions. So write down any questions that you have as the presenters are speaking. We'll have a lot of time to go over that. So Sebastian, you have the floor. His presentation is titled European Data Protection Legislation and Its Role in Multinational Military Operations.
Asaf, thank you very much for the kind introduction. Thank you to the audience for being here, to listening to us. So the title of my presentation is derived from topics and projects I'm working on in my capacity as a legal researcher at the center. And so before I say anything anymore, the disclaimer is, of course, what I'm telling you is my own opinion. It's not the opinion of NATO, the German government, or German armed forces, for whatever. So once we get that out, next slide, please.
I think you used the
check. All right. So why a European perspective? So data protection has emerged as a consideration for many activities done in the military context throughout the recent years. Well-known, publicized example is the biometric enrollment during the Afghanistan campaign, all the way back to Asaf. But also like the identification of targets, right? When we're talking about targeting combatants, that is something that has been coming to our attention more recently. But in this context, when we talk about this kind of campaigns, which are usually multinational, no matter under which security regime they are conducted, the exchange of data is, of course, also of the utmost importance. And it goes even beyond sharing in theater when you want to share this data collected in the military realm with civilian authorities, right? So me and my co-authors from the Netherlands, we wrote a paper on this topic, and we came to the conclusion, especially when we look at the Ukrainian-Russian situation or conflict, that this is a timely topic. So So, talking about the legal context, the paper we wrote is called Military Data and Information Sharing, a European Perspective. And why is that? Why focusing on European Union law? Well, on the one hand, we found the international legal regimes in place outside of the European Union, as well as state practices not very mature, not very concrete, nothing to really work with. And at the same time, we face the fact that the European Union emerged as a military actor more and more in the recent years. We see naval operations conducted in the Mediterranean, European training missions conducted in Africa, and all of this is conducted basically under the auspices of the CSDP, the Common Security and Defense Policy. So at the same time, looking at European Union law, we see this as kind of a benchmark for data protection legislation. And we see these kind of legislation having an impact all over the world, influencing organizations and states as they create their own legal regimes. So, as with most things, we should ask ourselves, what's in it for NATO, right? Why would we focus here at the NATO CCDCOE on European law? Well, for one thing, NATO consists roughly to 2/3 out of states which are also part of the European Union, right? So it's not only an internal topic that you should be aware about the legal regimes of your member states, but also NATO and the European Union their strategic goal is further cooperation, right? So it's definitely important to know how far what kind of legal constraints are there in cooperation and intelligence sharing. So much, I would say, for the so what, right? Creating a better understanding of data protection consideration will greatly enhance what we call legal interoperability within NATO, but also in concert with other international organizations. So, diving into the legal landscape of the European Union, first thing we have to focus upon is the primary legal layer, the European Union primary law, which is basically the foundation of the European Union, right? And the key provision here is Article 16 of the Treaty of the Functioning of the European Union. Article provides that everyone has the right to the protection of personal data concerning them. And this primary law source is supported by Article 8, for example, of the European Charter of Fundamental Rights, which formulates a similar guarantee. So these kind of provisions are pretty well known and explored, but what we focused on during our paper when we were researching it is a provision that is actually not quite as popular as those. One is Article 39 of the Treaty on European Union. And this is an article specifically providing that legal basis for the enactment of secondary law provisions for data protection within the domain of the CCDSP, the EU Common Security and Defense Policy, specifically calling for the enactment of a decision, which is a secondary law instrument provided for in Article 288 of the Treaty of the Functioning of the European Union. And so, therefore, we came to the conclusion that if we have a strong primary law foundation with regard to data protection, we need, of course, secondary law to implement this, to operationalize it for everyday life. So, looking at the secondary law provision, of course, EU Regulation 2016-679, the General Data Protection Regulation, very well known, the GDPR, which is some of them would call it the gold standard of data protection regimes, laying down rules relating to the protection of natural persons with regard to the processing of personal data and also the free movement of data. This regulation is supported by EU Regulation 2018-1725, addressing the protection of natural persons with regard to the processing of personal data by the European Union institutions, bodies, offices, and agencies, hence dubbed the institutional GDPR by my colleague here. So I'm sure we're going to hear more about this. But taking these two very important instruments into account for implementation of data protection in a European level, we came to the conclusion, or it was very easy to find, that there is a gap in secondary law, right? There is no secondary law instrument for data protection within the CSDP domain. So, consequences of this is, of course, that we cannot just normally and easily turn to the GDPR or the institutional GDPR because, as Eduardo said yesterday during the book launch, of course, the scope of limitation is limited of both of these regulation. They explicitly exclude their application to things which are outside of union law, which is defined, for example, as national security. What that compromises would be, for example, intelligence activities, but also most likely military operations. And they also exclude themselves from being applied to the CSDP, because they're referencing to Chapter 2, Title 5 of the TEU, making clear that there is a special regime to be found. But seeing that with this decision missing for the CSDP, and at the same time the understanding that the fundamental European law provides that data protection needs to be ensured all over the place and all over the legal topics, we were focusing our attention to national solutions. And one of the solutions that I was able to find, because my own country produced it, was that we were aware of this limited scope of application and therefore legally extended the GDPR to military operations using a provision in our national data protection law, paragraph 1, subsection 8, effectively making the GDPR applicable to the military. So the reasons for this was that we did not want holes in our national data protection landscape. And I believe that also we came to the conclusion, looking at the provisions of the GDPR and its underlying principles, that is actually not a super bad fit for military affairs. So what we can deduct from this is at some point that there are some nations in Europe considering GDPR's provisions at least useful or at least operationable for military purposes, and that one of the ways to achieve this would be analogous application or just national law expansions. And with this in mind, I would like to focus on biometric data processing, which was one of the showcases we provided in our paper with regard to data protection. So biometric data processing has been identified as a key challenge for data protection regime, and I believe it's at the crossroad of technical, legal, operational aspects convergence within military operations. Not to mention that it has been repeatedly mentioned here throughout this conference. It has not only has a historical value. I mentioned already the Afghanistan campaign, where it was used for biometrically enrolling Afghan citizens to organize base access for locally employed personnel, but also in the Ukrainian-Russian conflict, we saw this as there was clear news coverage that Ukraine has been using facial recognition to identify dead Russian soldiers and use this information then for their purposes, whatever they may be. So how to address biometric data processing in a military context, right? So looking at the GDPR, we'll find ourselves looking at Article 9, which employs a very interesting structure, because the first paragraph of Article 9 actually prohibits the processing of, amongst other things, biometric data, which is, of course, due to its sensitivity. Yet the second subparagraph is an exception for that rule pertaining to reasons of substantial public interest. And that being said, I believe because of this structure, prohibition and exception, this exception has to be understood narrowly, right? So a decision on CSDP data processing could possibly create a different kind of reasoning for this topic, yet if we are right now looking at the German situation, we built actually up on this provision and provided in paragraph 22 of our National Data Protection Act a possibility to process biometric data for imperative reasons of defense, effectively opening the door for our nations to doing this. So what we can conclude from this small part is the fact that the European Union landscape provides instruments for addressing these kind of data protection topics, but we need to utilize this in a way that is actually applicable and therefore achieve a balance between data protection and military necessity. And so that leaves me with my last slide, the way forward. And I would say biometric data processing is a great example to see the challenges that are posed by data protection in a military context, being it European Union or NATO. And what we definitely know is different legal standards will always hamper the effectiveness of a military operation, can even put the success in doubt. So therefore, working towards solutions, thinking of ideas how to overcome this obstacle, I think is of paramount importance for the conflicts to come, right? In the meantime, I believe mitigating, raising awareness, which this conference here is a great opportunity because the topic was very heavily featured here. Showcasing possibilities that some nations, also the Netherlands, if I'm not mistaken, apply to GDPR to their militaries, shows that I think there is something to work with. And throughout the conference, what I always heard was the argument that we should never try to reinvent the wheel for all our problems, but maybe look at the solutions we have at hand, right? And if everything falls, we can always resort to an analogous application and see how far this brings us. But not to overstay my welcome here in my time frame, let me conclude with a couple of recommendations. I'm a German lawyer, so I believe in written laws. So striving towards legal harmonization, I guess, especially at the European level, it would be a very great idea to enact this kind of directive. And it would even give us the benefit of tailor-making data protection regime for military operations of the European Union. Looking at Article 9 again, right? It's absolutely imaginable that for a special data protection regime, we could say for the CSDP that, hey, biometric data processing is allowed in general, provided legal safeguards are met, which can be laid down also as well. And that would greatly enhance the possibility to conduct this mission successfully. And lastly, because that is also one of the things that I'm heavily involved with at the CCDCOE, I believe we already need, despite all the uncertainty and all the questions we discovered during this conference, I think we need to train our operatives in this. I think we need to integrate data protection questions into our military exercises. And I can assure you the ones I'm responsible for will feature this heavily in the future and provide training for our officers or experts to be familiar with this. And with this, I would conclude my presentation.
Thank you so much. I truly think that Germany is in the forefront of setting some of these standards in ways that very few other militaries have even started the conversations that you just heard Sebastian share with you today. So we're moving straight through. Our next speaker is Deborah Hansen-Couriel. Deborah is the Chief Legal Officer and VP Regulations for Konfidas Digital Limited, a leading Israeli cybersecurity data protection and crisis management company advising on high-level strategic legal planning and regulatory compliance in the areas of cyber preparedness, data protection, corporate governance, and cyber incident response. Deborah's experience at the international level includes her work as a member of the international group of experts that drafted the 2017 Tallinn 2.0 manual on state activity in cyberspace. Deborah is currently, I call her Deb, Deb is currently a member of the advisory board for the Hebrew University Cybersecurity Research Center and a research fellow at Reichman University's Institute for Counterterrorism. She teaches at Hebrew University's Law School and Reichman University and has served as a guest lecturer at the Harvard Kennedy School's Exec Ed program on cybersecurity, the intersection of policy and technology. In 2011, Deborah co-chaired the Regulation and Policy Committee of the National Cyber Initiative, launched by the Prime Minister's Office. And in 2013-2014, she served on the National Cyber Bureau's Public Committee on the Cyber Professions. Deb is also one of the core experts for the manual on international law applicable to military uses of outer space, the Milamos project I'm sure most of you know about. She's currently researching innovative polycentric regulatory models for info sharing to mitigate
Asaf, I'm going to sit down.
No, that's it. I'm done. That was the end.
You did a lot more than me.
And 4 kids. So you're on the way, right? So thank you, Asaf. I really appreciate it. So on September 23rd, 2016, Ardit Ferizi, a hacker from Kosovo, was sentenced by the U.S. Eastern District Court in Virginia to 20 years in prison for his hacking activities and acts of terrorism. What Farizi had done, according to his indictment, was to supply his ISIS handlers, including one of the leaders of the ISIS hacking division and cyber Khalifat, I hope I have that right, his name was Junad Hussein, with the personal data of more than 1,300 active US military personnel and government personnel and their family members. This is what it looked like. Names, addresses, photos, and other personal details were shared, and they were published no less on the US Central Command's Twitter feed, which had been specifically hacked by the ISIS hacking division to publish these kill lists. And they were so called, and you can read for yourselves. They're a little bit fuzzy because these are old pictures, but American soldiers, we're coming, watch your back. We won't stop. We know everything about you, your wives and husbands, they forgot, and children. So this is perhaps an extreme example of the problem we'll be discussing over the next few minutes, but it's not the only one. So in 2018, some of you may be familiar, many of you may be familiar with the fact that the Pentagon reviewed GPS policies after soldiers' Strava data for a non-military app for tracking physical workouts were exposed and leaked broadly, and which enabled GPS location of thousands, tens of thousands, I think, of US military folks. And then the leaked spreadsheet exposes details of UK Special Forces soldiers. These are leaks that are not infrequent. Many of them are not transparent, so just sharing a few that we know about. So the question that I'm going to try to answer in these next few minutes is why the sharing of combatants' personal data, combatants, I have that right? Combatants, I think, which is sort of the opposite side of the picture. A lot of the times we look at protection of victims' personal data or third parties. We're looking at the military personnel themselves. Why that, which includes sensitive biometrics, as you've shared, within military coalitions for necessary operational and administrative purposes. Why is that becoming increasingly critical as an issue of legal interoperability in military coalitions? So the examples that I cited are not leaks from military coalitions, obviously. They're from third-party providers, but the issue is the same. Coalitions share personal data of combatants all the time. So the need to explore how domestic data regulation arrangements, which you've shared with us specifically, how those domestic data protection arrangements might be coordinated, and that's really the basis of this analysis. So the best analogy that I could find during the research for this book chapter was a bit out of my league, but I learned a lot about how IHL practice on a nation-by-nation basis is coordinated in military coalitions on a regular basis. And this legal interoperability exercise is really, really critical for military operations. One example that I wanted to share is NATO's International Security Assistance Force, the ISAF coalition operations in Afghanistan, where you participated. I learned over lunch. What? He neither confirms nor denies. At the height of coalition operations, more than 130,000 troops from 51 countries participated in extended and varied operations on the basis of UN Security Council. So conflicts of IHL interpretation among the member countries included a wide variety of issues that needed to be bridged and needed to be turned into practical interoperability mechanisms so that the coalition could move ahead with its work. And again, we're still in the IHL context. So issues such as the nature of the conflict itself, the rules of engagement, rules applicable to the detention of combatants and non-combatants, targeting criteria. So issues like this are subject to coalition members, I learned, red flagging, and national caveats for the use of the military forces. It has to be that way. Summing up this tension between domestic provisions of IHL interpretation and IHL doctrine, David Goddard wrote in 2017, stay with me through the quote, individual states may be responsible in law for some, though not necessarily all, of the activities conducted under the auspices of a coalition of which they're a part. As a result, each coalition member has a particular interest in satisfying to its own standards what the lawfulness of the conduct of its troops are in military operations. So the emphasis is as follows. The challenge ultimately concerns the need for states to protect their own legal interests while minimizing the impact on the overall effectiveness of the military coalition's operation. So focusing on the protection of these types of legal interests, moving from the interoperability model or paradigm from IHL into data protection, this is what was really explored in the research that I did. How does this paradigm of IHL help us to understand the need for data protection interoperability? Well, let's give it a shot. First of all, let's put aside bullet 2.3, which is the cybersecurity issue. It's a critical issue, obviously. Any data sharing that's done on the part of members of coalitions obviously has to be on the information sharing platform that's used. It obviously has to be tightest possible cybersecurity controls. That's a whole other presentation and a whole other issue. We do need to note, just to mention, this is part of the discussion, it'd be great to have questions about this later, that GDPR and other selected national rules, national regulations on data protection, do incorporate technical measures for cybersecurity. So the NIST, which Asaf already mentioned, the TOMs in the GDPR, these are all the ISO 2700 and 27001. These are cybersecurity measures that are sort of the underpinnings of data protection. In some regulations, more declared, and in some less. We're putting that aside for a moment. It's a whole other topic. It's a critical one, but we don't have the time to go into it at the moment. What I found so interesting about what's left of the issues to discuss is that they're not exactly IHL. In fact, as we discussed yesterday in the book launch, probably not IHL at all, at least not in its present form. Not really international law, not quite domestic law, but somewhere at the nexus of all of these. And that's what was so intriguing to me. So what's the problem? Here we have a sort of stylized version of how coalitions share information, or more what types of information they're going to share, mostly operational. But just sort of turn in your mind the personal data that's included in all these particular types of military operational data and administrative data and HR data that are shared on a regular basis by any military coalition that wants to get its job done. Okay? Taking the NATO case as an example, which was the main case study of the article, just sharing the tip of the iceberg here. Within a NATO coalition, typically on a regular basis, look at the quantity of data protection regimes that we have in place on a day-by-day basis, on an hour-by-hour basis. So we've heard a lot about the European regime. It's obviously a leading one, and for most of the coalition members in NATO. But we've got Canada, we've got the US, we've got, I think we have the Maldives. I'm not remembering the other two flags. Others may be able to help me. And we have the US, which, as we all know, does not have a federal data protection law yet. Lots of bills running around in Congress for that. But we do have HIPAA. Okay, so even thinking at the initial level of how we do legal interoperability of these regimes alone, and leaving aside the fact that on specific NATO operations, there's going to be more and more and more and more countries that are participating and are going to be needing to share personal data on a regular basis. How do we even think about this? And more than how do we, once we start thinking about it, how is it a substantive legal issue? And this, I admit, may be a bit of a stretch, because I'm going to sort of give the promo for one of my conclusions in my own mind, anyway, is that we really have a good techno solution or practical solution to a legal problem. And I'll get to that at the end, so just giving you a little bit of something to think about. Why is it important to have interoperability of data protection regimes? So look at some of these issues. Weapons use. Some countries may have, as part of their operational doctrine, limitation on use of certain weapons by people with certain health issues, physical health issues, mental health issues. That data needs to be accessible for the purposes of that particular country. As an example, geolocation of competence on leave. Does that belong to the military? Should it belong to the military? How do we deal with that? Where do we store that information? What do we do with it? And how do we resolve the conflicting approaches of different countries? And finally, as in so many other contexts, COVID-19 brought us the prime example of where this is really a problematic issue. So COVID, and this is one of what COVID has required military coalitions to do, as a matter of course, is to receive sensitive personal information under all of the data protection regimes that we know about the health of forces that need to be deployed. So if contingents of country A have been swept by COVID-19 infections, they can't be deployed. Okay, that kind of information is critical on a day-to-day basis in military coalitions. How does NATO look at that? So I'd be very happy to have any of the NATO folks in the room enlighten on this point. I read every single NATO document that was published that possibly approached this issue, and I did find a little bit of a hint that indicated where NATO is on the topic, and it was not very encouraging, because read the bottom lines. The struggle to engage in this legal interoperability was very much acknowledged by NATO under its joint doctrine for medical communications and information systems. Terrific, but no solution has been achieved so far, at least not a solution that was shared publicly. So currently, the creation of an all-NATO approach to how to do this legal interoperability of data protection regimes is in process. Again, if anyone knows different in the room, I'd be absolutely thrilled to find out how that's working. So, but at least it's been pinpointed in this issue. Goes back, Asaf, to bring these topics up in order for us to start thinking about how to deal with them. The detailed analysis of the GDPR and the institutional GDPR, I'm going to leave aside. You can read about it in the article, but it does leave, it's really a re-emphasis of your point that there is a little bit of an opening under the institutional GDPR. I know you and I have a difference of opinion about how wide that opening is. We can talk about it a little bit later. I want to get to some of the final points. Where does this complexity lead us, and when boots hit the ground? I love that metaphor. So metaphorically and physically. So countries need to look much more carefully at their own data protection regimes in order to understand how their militaries are compelled. And you've given some examples of an example of at least one country that's actually looked at this. What do countries want to bring into their own understanding in terms of active military activities in terms of the data that militaries that needs to be protected even in military context? So that's task number one. And the law will determine that. There may be carve-outs, but it's a legal issue. Get the domestic law straight, and then the next task is to start having these conversations in the context of the military coalitions. And that, I would close the circle and bring us back to the IHL interoperability discussions. Those are issues for red flags and national caveats. Okay, same. For the how, I want to get back to the issue of really quickly to a really interesting technical solution that helps, I think, to solve this legal problem. And it was kind of a surprise to discover this. Any of you who work in the data privacy field, Eduardo, you may talk about this later, knows that RegTech is a big deal. The regulation through technology. So platforms that allow for in the private sector for companies to figure out which data subjects enjoy which rights under which regulation. So a company called Archtis, I've spoken to them. I have no stock in the company, so this is not an advertisement for them. They've done this for multinational coalition operations. They have a product on the shelf that actually does this for data protection laws. And it was a fascinating conversation with the two sales reps. I called them and I said, look, I'm not in the market to purchase, but can you tell me about what you do? And it was spot on. It was really a tool that they put in a lot of effort. Obviously, the cybersecurity issues come in sort of from how are you going to protect this platform, but the RegTech exists. So it's an interesting, you had asked us to look a little bit at the private sector contributions. The private sector is already doing this. Let's see how we can sort of bridge those gaps. Concluding points, challenges, and trends, and I'm 4 seconds to go. I want to leave you with what really keeps me up at night. So you can read through the slide, which does the summary. Where I'm really restless and really concerned is with the two sort of top bullets. big things are happening with digital identities of all of us. And the military is not exempted from these dramatic changes in how we are constructed as human beings in the digital space. And anyone who believes still that there are any boundaries between our civilian identities and our military identities and our commercial identities has it all wrong in my respectful view. How are we going to start to think and cope with, in terms of in the context of military coalitions, with the absolute merger of digital identities of soldiers, individuals who provide support, and their families? And what do we do with this wealth of information about their identities once it's all on a shared platform for military coalitions? And finally, what's really keeping me awake, and then I'll finish with this, is that increasingly, as weapons become more and more digitized, and the capability of tracking what's done with a particular weapon and what it does in the hands of a particular individual may very quickly bring us to a point where we not only know which combatant has used weapon X to inflict damage Y, but who on the other side of the lines are the person or people that have been killed by that person or injured by that person, including collateral damage victims. Once that's all digitized, and I'm not sure it's too far away, how do we manage that piece of digital privacy? So I'll leave you with that. Thank you.
What I think is particularly fascinating in Deb's book chapter, and the presentation today highlighted that, is the fact that she chose to focus on military personnel. I think that it is unfathomable for a military to say, just because you chose to serve, in some countries chose to serve or are mandated to serve, you somehow lose what is constitutional protections or are entitled to lower protections. And so that automatically generates these obligations that might be at play in these contexts. And the fact that there's a product on the market suggests that there's clients also. And so to the extent that anyone in this room was thinking that this is kind of future-oriented, pie-in-the-sky discussions, it really isn't. It's live and well in the work of militaries. And with that, we're going to move to our final speaker for today, which is Eduardo Ustaran, global co-head of Hogan Lovells privacy and cybersecurity practice. Eduardo is widely recognized as one of the world's leading privacy and data protection lawyers and thought leaders. With over 25 years of experience, Eduardo advises multinationals and governments around the world on the adoption of privacy and cybersecurity strategies. Eduardo's presentation is titled Applying Data Protection Impact Assessments in a Military Context, Why and How.
Thank you very much, and good afternoon, everybody. So, in a sense, as I was listening to your presentations, I felt that we were running this panel a bit like a military operation from the point of view of, I think we heard a very strategic approach to the legal framework. And then we focus on the very specific issue of the interoperability of laws in the context of the sharing of data. And I want to go narrower into a particular tool, exploring a particular tool that I think would be and will be increasingly relevant in the context of achieving what the main question of the panel was about, fair and proportionate use of data in the context of military operations. And that is the role of data protection impact assessments. And you may or may not have heard that term before, but my mission here is to show you why this is relevant and how it can help you in achieving this compatibility of your mission and the use of personal data. And the starting point, like this, the starting point of most things, is to explain why this is relevant. And I also thought that it would be easy for all of us involved to start with something that perhaps you are more familiar than even I am in this context, which is this concept of international humanitarian law, the body of law that regulates the conduct of armed conflict. And it is at the root of that we start our mission here and our action. Because within that body of law, and of course which originates from the conventions, from the Geneva Conventions, there is one particular piece of legislation and one particular provision within the first additional protocol, which is Article 36 of that first additional protocol. And you may or may not have read that. But what it says is that in the context of armed conflict, there is an obligation to determine at the outset, so before anything else happens, whether the employment, and by the employment we mean the development, the actual use, the way in which a particular new weapon can actually be used, and to what extent that may actually be prohibited by that body of international law. And that is an obligation that already applies and has been in operation for a number of decades. So when you look at that obligation and how you operationalize it, as you also refer to, the question is, so what is prohibited by international law? We see so many things that are happening in today's conflict that you would think, well, isn't that prohibited by international law? Isn't that sort of action, we're watching it live on TV, isn't that prohibited? And in that context, you may be more familiar with these terms and these ideas that something that is prohibited is this idea of having a weapon, for example, that infringes the principles of humanity and the dictates of public conscience. But that's quite woolly. In the whole scheme of things, that's very sort of abstract. If we go a little bit deeper, what we really encounter almost immediately is that in that deployment of weapons and in seeking that illegality, if you want, or confirming the legality, one of the important aspects is actually the rights of individuals, our rights as human beings. And there is a whole body of law that goes in parallel with the international humanitarian law, which is the international human rights law, which of course includes, amongst other things, the right to privacy. And this seems to suggest that in applying that Article 36, that idea that one has to verify and analyze and determine whether what we may be developing or what we may be employing is prohibited. One of the factors to take into account in the law today is to what extent that may infringe human rights, including the right to privacy. Here is where my friend, the GDPR, fits in. This is my more familiar territory. We've heard about the GDPR and how it came about modernizing a few years ago the existing framework of data protection law in Europe. It's been in operation for exactly 4 years, and it's still developing. But there is an element, there's some articles, one of the new aspects that was created by the GDPR, which is in Article 35. Of the 99 articles of the GDPR, Article 35 is the key one in this context. Because even though it bears no relation to the first additional protocol, it does have a degree of similarity, because what it requires is to undertake an assessment of the impact of the use of data. So we're not talking of necessarily a weapon, but the use of personal data. But especially when new technology is being developed and is being employed, and to assess whether that impact is likely to have an adverse impact, a high risk to what is called the rights and freedoms of the individual, again, including the right to privacy. This is where the concept of a data protection impact assessment can be very helpful in relation to the Article 36 of the first additional protocol. So we go from something that was created in 1977 to something that has now been devised in the context of the most modern and ambitious, perhaps, data protection framework in the world, and how one relates to the other. And this is why the deployment of a data protection impact assessment may actually be very useful when assessing compliance with international humanitarian law. The question is, how do we do that? How do we do a data protection impact assessment? As I said, it's new. 4 years ago, there was no law in the world that had this type of tool at our disposal, not only in a way that we could use it, but in a way that it is compulsory to deploy it in the context of the use of personal data. So how to do a data protection impact assessment shouldn't be too complicated. It's even doable, let's put it this way, in the battlefield. And the way it works is that, of course, you need to understand what type of uses of personal information a particular weapon, for example, may involve. And there is a degree of information gathering, if you want, where you need to analyze the facts. So let's just use a practical example here to bring it, I guess, closer to home. Let's imagine, for the sake of it, that we are devising or designing a new drone. And this drone is going to have the ability to use biometric information, which you refer to, specifically facial recognition technology. And in addition to that, it's going to have the capability, using, let's say, artificial intelligence, to make decisions as to how to deploy the capabilities of that drone. So that drone is going to be flying around, looking at a particular population, and maybe, just maybe, identify a particular target. So how would that work? How would that new weapon comply with this Article 36, with the idea that how is this going to comply? And amongst all the other issues that one would need to look into, you would need to look into the extent to which the use of information, the application of facial recognition technology in that particular context is indeed lawful. So here's what an assessment of that technology would look like. You would look at a number of factors, a number of principles, if you want, that are covered by the GDPR, by European data protection law. But these are principles that, in fact, going to your point about interoperability, most legal frameworks around the world that have been developing data protection law over the past 30 years will have in common. So let's look at those factors and how our imaginary drone may comply with it. Transparency. This is a really tricky one. Transparency is about telling people what you do with your data. It's easy if you're selling online and you put a privacy policy on a website. If you are flying a drone that has lethal capabilities, how are you going to explain to people what that does? So there's a degree of complexity there involved, but one would need to understand to what extent there is information out there about the capabilities of this weapon. Legitimacy is all about making sure that the actual use of data is in itself lawful. And of course, we're now talking of the laws of war. And whatever derogations apply will also apply in this context. But it's still part of the assessment that is undertaken. Purpose limitation. What is the purpose of this? Not just the weapon, what is the purpose of the facial recognition capability? Are we creating a database so that we can then share it with our partners, or are we just deploying that in order to take out a target? What is the purpose? And it should be specified at the outset. Data minimization, again, a very tricky one to implement in practice. We live in the world of big data. The more data that we have, the better. At the same time, we have a principle, which again is pretty much universal to all data protection laws around the world, saying, well, you should only be collecting the data that you need for that specified purpose that you have identified. How do we know what is sufficient and what is too much? Well, this assessment will look into that. Accuracy, well, I guess this is the one that the operational function is very much aligned with the legal assessment, because we want to get it right. We want to make sure that the target we are chasing is the right target, of course. Storage limitation. All this data that is generated, all this information, all these bytes and megabytes of data, where is it going to go? Where is it going to be kept? For how long? What is the exposure of this information? Will it end up on the internet, like in the case that you were talking about? So retention and how, and again, the period of retention, the method of retention is essential. Rights. Well, how do we deal with rights in this context? A right that we have under data protection law is to understand what information is being collected about us and to have a say. How does that impact in the context of a weapon? Again, the limitations there of the law of war will have an important role to play, but it's something that we need to take into account, particularly if the data that is being collected is data of civilians, for example, that are not involved at all in the military operations. Data security, well, this is CyCon, so I guess we don't have to say much about that, but the importance of ensuring that all this information that is used and is collected is appropriately secure should have no or deserve no explanation. And finally, one of the most interesting things I've learned at this conference over the past couple of days is the emphasis on international cooperation. And it's interesting to see that, again, at the panel, for example, this morning about the war in Ukraine, how one of the key messages I took from that was the importance of international cooperation partnership. Well, if the data is going to flow across borders, sure, that is necessary, but how do we protect it against regimes that may not be allied or maybe neutral, but are they involved in some way? Are they on our side? Are they on the other side? So the international data flows are a key aspect. So I finish by saying that this is a tool that already exists. It's a tool that can be, let's say, adapted to the theater of war. And it's a tool that, if used sensibly and practically, it will be very useful probably to all of you. Thank you very much.
Thank you so much, Eduardo. I think it was yesterday where the president of Estonia spoke, and one of the examples the president of Estonia gave was the move of data, of Ukrainian data to the cloud, which required changes in Ukrainian legislation and was done quite in a haste, in part because of the security concerns relating to the Russian invasion. I think that is a perfect case study for thinking through data impact assessments and how we might be able to engage them, especially when we have shorter time constraints compared to, say, a full Article 36 review. It also brings a lot of questions for me about what is subject to an Article 36 review in the first place? In particular, how do we define means and methods of warfare? And how much, as militaries engage in various AI activities and AI applications, how much should be subjected to these sorts of reviews that could potentially incorporate some of these practices? Very, very, very interesting stuff. I wrote a bunch of questions for each of our panelists, but I'm not going to ask it until I see that there are no hands here. So my hope is that there's a ton, because this has been so interesting. So we're going to take any question from the audience. Just raise your hand. We're going to, oh, there's a bunch. Great. Love it. So we're going to do 2 at a time. So Anne?
Hello. Is it switched on? Yeah, now it is. So I'll make use of my organizer's privilege, and I have a personal mic, so we can show whenever I wish. This question mainly goes to Eduardo, and I agree with you on so many levels, and have published a paper expressing similar but not quite the same ideas myself some 2 years ago, I guess. And I ran against some heavy practical issues. Namely, in your view, who and when should be responsible for integrating data protection impact assessments into weapons review, and how should it be done? In the procurement phase, in the development phase of a specific technology? Is the company who develops these capabilities responsible? Is the military organization deploying them or buying them? Your views. Thanks.
Thank you. So
we're gonna just take
okay.
2 questions at a
Sure,
time,
sure.
just to give more opportunities for. So we're gonna move straight to Darsha later. Yeah.
Hi, thank you very much for all of this. I have an interest in this. So Lieutenant Colonel Daria Eastlake from the Office of the Judge Advocate General for the Canadian Armed Forces. So that'll kind of already give you my slant probably. So obviously not a member of the EU, coming from Canada. I'm going to read with interest if you're writing this out, because I go step by step by step. And I think I'm just flagging a few observations to begin with, because I'm not going to make assumptions that Article 36 this is even going to apply. And part of it is also when I look at, obviously who are parties to Article 36 within Additional Protocol 1, of course, not the United States and not Israel, but depending on how they view customary international law. So that's a first aspect. Second of all, it's our obligations as we interpret the applicable state interprets international law that's applicable to them. So that's another area that I'm going to flag. And then as I kind of continue through that, you're also at this intersection of IHL and then international human rights law, which I think is always fascinating and contentious. And then even in there, international human rights law versus national human rights, and we get into jurisdiction questions. So if I was to put on a professor hat, I think, I would be looking at all of these potentially as stumbling blocks, which are going to offer off-ramps. And that's not what you're trying to achieve for buy-in. So I guess my question to you is, if I park it and say, forget the law, can you not approach this from a policy decision where states or militaries or other organizations, did you consider that from a policy perspective, just from a cautious perspective, that they might just want to take that similar approach with those principles without feeling that they're legally bound to do so? So I put that over to you. Thank you.
Okay, so let me address those 2 things. In a sense, they are related, I think, the 2 questions. First of all, let me, if I can use some of the terminology of European data protection law and the GDPR, that may help understand the who and the how. Some of you, maybe all of you, know that European data protection law creates obligations that apply to 2 types of players, let's say. We have what we call controllers, and we have what we call processors. And the very simple way of understanding this, the controller is the one that is actually making decisions about the data. So this is the data that I'm collecting for this purpose, and therefore I control the data. And then the processor is, in a very, very sort of simple way, the service provider, sometimes the vendor, sometimes the third party that is, let's say, helping that controller achieve its purpose. Data protection impact assessments, and I think this is also very relevant in the context of Article 36, would apply to the controller. It is the controller that is subject to the law. The question is, what if there is a controller, let's say the military of a given country, that is asking a vendor to develop a particular weapon? And I think there, in my interpretation of the law would be that, in principle, the law applies to the controller. So again, the government of that country that is intending to use the data, and they are the ones that are effectively going to employ and deploy. But of course, the vendor, and again, we see that in the not in a military context, in every single other contract, a vendor that is necessarily developing a particular use of data will have to bear in mind that the functionality of that particular, again, use of data or weapon complies with the law. So the law may apply to one, but it is actually the developer of that particular use of data that will, in practice, quite often be subject to it, if that makes sense. If I can address the other question about whether it's sort of as a matter of policy, the thing about policy is that, as I see it, is subject to the political aims, perhaps, of a government or a group of institutions like the European Union, for example, or the European Commission, and therefore is more subject to change or is more subject to influence than the law is. The law, at the end of the day, is only subject to the true influence of the courts, because I'm a lawyer, but I'm not going to, and I may interpret the law, but ultimately it'll be a court, not even a regulator, but the court that interprets this is how the law actually functions. From a policy is something that I guess you have a little bit more room of maneuver if you want. But the question is, in my view, to what extent, if the law doesn't apply, whether you may feel, or again, a particular country may feel morally bound to apply a particular policy in order to achieve a purpose. But as a lawyer, that's outside my remit.
Sebastian, I'd be curious specifically about this policy point. If you could elaborate a little more about what drove Germany, in the example you gave, to extend the GDPR in this context to a domestic legislation.
Absolutely. First, I wanted to support one thing with regard to Anne's regard, the question when and how to incorporate these kind of considerations into the development or the procurement of weapons. I would say, obviously, if the state already indicates that he will only be interested in tools or weapons that pay attention to this kind of consideration, then companies will be bound to include them in the very first stage, and that is something that is basically not happening right now in Germany, as I see, because we're developing tools, let's call it tools or weapons, and we don't. Companies do not pay attention whether or not we would be legally able to use. But coming back to the point, I mean, we actually to the German point, your point, Asaf, is the fact that we consider this as a pretty important. Right, data protection, something very important. So we decided that we do not want to have a regime that consists of different kind of loopholes. So military operations or the legal affairs of the people actually serving in the military, being them soldiers or civilians, should be governed under one regime, right? And we found these kind of considerations in the GDPR, all the things that Eduardo laid out here on his slides, as universal, right? So I would always opt for one legal regime covering it all, providing special subsections for for different circumstances. And so far, I have the feeling we fared well with this. It's not very well known. I found out in my own country that people are quite surprised that we have two distinct provisions in our law code addressing this. But who knows? Maybe it will down the road will maybe serve as a role model. So.
Deb, anything from you?
I think the question, really quickly, I think as you're both speaking, a mapping project, a mapping initiative needs to be done. I just started in a little bit to really see beyond Germany which countries have included these sorts of policy mechanisms, which are the workaround, right? Because the law is going to take a lot longer. So I know that the UK, I don't know if anybody is here from the UK military, but I know that the UK military has a data protection policy on its website that's very GDPR-like. How far down does it go? Probably not as far down as Germany, but that's one example. I also checked for Israel. Israel has absolutely nothing. No surprise there, but we will probably need to. So just to be really quick, I think that's sort of a next step, is to really map out where militaries are on this, given materials that are already available.
Mm-hmm. Any more questions? The mic is coming around. It's coming around. So over here at the front. Sorry.
Okay, it's coming. Thank you very much. Thanks for a fascinating panel. From a policy perspective, I can imagine, and this is to all of you, whoever wants to take it, I can imagine that it could be in the interests of certain states not to harmonize legislation, because it could be to their advantage that they are different legislation. I mean, if you think about this in terms of the use of different legislation when it comes to human rights in the war on terror, for example, various states took advantage of this to be able to do things that were illegal in their country but were illegal in other countries, right? So I can imagine a policy reason why states would be reticent to harmonize this, because they could use it to their advantage.
No, I saw another hand right there.
Thanks, Captain Nick Stark from the Army Cyber Institute. Really appreciate the conversation. I can attest that at least one other small corner of one other military is thinking about this problem. And the question that I would like to ask is maybe have a deeper conversation around what the military context means. So I think Strava is a great example of this. The military or a military did not collect that data.
Absolutely.
The release of that data, that decision was made entirely legally by a private company and yet had operational consequences. As we think about the application or assessments in the development of weapons, we see this in Ukraine right now, the use of, find my stolen iPod headphones being used in a military operational context.
Wow.
The use of geolocation on Tinder in a military operational context. So essentially, what is the military context when it comes to open source data, and how do militaries protect themselves? Thanks.
I'd love to respond to that. Oh, you're collecting?
No, two are good. I know if you want to.
I mean, addressing your points, I would say that is a question that comes to discipline of the kind of devices I'm using when I'm in the military, right? Because the examples you brought was the usage of private tools, websites, whatever, by servicemen, right? And this is what I mentioned about like raising awareness, training them, not to sit in a class 2 area, writing WhatsApp all the time, or like getting rid of these when I'm jogging in Bagram, something like this, yeah? So just my thoughts about this, that this is a little bit of a, it's super important, but the other thing that you mentioned is actually, coming back to what Mike Schmidt says, the interest in the panel before us is the point that for some countries it might be interesting to be like out of this corner. Well, I was talking about the European Union, right? And I assume that we have an absolute shared interest and common understanding how we want to conduct all of our affairs down to our military operations, whatever they will be in the future. So I would like to believe that we can overcome this attitude. So.
I would love to dig in. I love those comments. So interesting. Because first of all, that's it echoes what keeps me up at night. I differ from you, Sebastian. I don't think there's any way on planet Earth to get human beings to not use their Find My iPad app even if they're in the middle of combat. It's not going to happen. So those multiple digital identities of competence are part of our lives, and this is only going to become a more compounded problem as time goes on, and the depth of that personal data, the haptics, our DNAs, it's going to be part of whatever identity pods we have in the digital world, and I think it's real. So I'm in debt to you for bringing that up. It's a great example. Your first point is, I think, something that is worrying but can be dealt with. That's the issue of military suppliers and vendors, in your language, Eduardo, and how the military is going to start regulating, in the first instance, vendors that they officially work with. So DoD already does a lot of privacy and other requirements of their, I just read 200,000 something suppliers on a regular basis. A lot. Market determinative supply situation. So that's something that's got to be really red flagged and looked at. What do we do with third-party suppliers that are part of the voluntary human activity of competence, and their families, by the way? Huge challenge. So I'll leave it at that. I wanted to throw one more thing out that connects with what you said, Eduardo, so I'm going to take advantage of this. So there's a GDPR provision that's not yet a requirement on companies, but it's called data protection by design and by default. I know you can talk a lot about this. So it imposes not even a requirement, a suggestion, a strong recommendation that anyone who's supplying a service or a product, including military products, I would assume, to anyone in the European Union needs to think hard. Again, it's not quite a requirement. Have in the production of the supply of the service or the production of the product, sort of the pre-ready regulatory compliance with the GDPR. How that's going to, I think the Commission has promised to develop the thinking around that and the enforcement around that in the coming years. You can speak to that probably with a lot more depth, but maybe that's something to hang our hat on.
Yeah, and just to add sort of, let's say, a legal technicality to your question, which is fascinating, is so the scope of application of a law like the GDPR is determined by two things: whether an entity is based in the EU or the UK, for that matter, or whether the use of data involves people in the EU or the UK, for that matter. But so obviously, you could say any US company, unless it's doing it in the EU, it wouldn't be subject to it. Let's assume for a moment that we're talking of the military forces of an EU member state, or again, the UK. There is an argument that one could make that the elements of national security are outside the scope of the GDPR. Okay, let's not have that debate. Let's just assume for a moment that it does apply. So in theory, again, under that assumption, in the context of the use of any type of technology, whether it's not military technology, but it's civil technology for military purposes, that the Army would be required to undertake a data protection impact assessment. But here's the important point. A data protection impact assessment is not a process to tell you that you cannot do something. You see what I mean? It's a process to tell you how you can do something in a way that is compliant. And in applying that approach, what I always say to my own team when we advise clients is, we need to remember data protection law is not in conflict with common sense. It's not in conflict with what is the right thing to do. So I think one needs to ensure that when applying the law, no matter how technical the issues are, you do apply particularly in the context of a data protection impact assessment, through the filter of what is the right thing, what is the right aim, and what is what, in a sense, common sense dictates.
So I will take some more questions. I do want to throw in one more thing to think about. When I was working for Privacy International, we applied and were granted a FOIA request that was the first to release some of the UK-USA agreements around the Five Eyes arrangement. And these are arrangements from the 1950s, 1960s, a very old document, predates GDPR. And yet, some of the language of that agreement, and I encourage all of you to go back to it, uses data protection language about the way intelligence sharing is done in the context of these operations around originator rule. That is, when I share information with you, I have final say when you want to share it with third parties. A lot of kind of tidbits of kind of early day data protection standards have been incorporated into the UCOSA. And the reason why I'm interested in that is because as I think about where we are now, you had suggested that we look at what each country does or publicly and so on, I think that a lot of the answer to the puzzle is hidden in bilateral status of forces agreements. And I think that there's a lot to ask about that, even for an international lawyer who's really interested in the hardcore secret treaties, how they apply, what their meaning is. What do we do when the treaty revokes a lot of protections that might exist under domestic law? Is the contract void? Do we void it for public policy reasons? I think there's a lot to think about there, the intersectionality of contract, secret treaties, SOFAs, and in this context. Just a thought that occurred to me in the course of our discussions. Any more questions from the audience? Okay, terrific. Over there.
Thank you. Peter Pijpers. I'm on the one hand a lawyer, but I'm also military, so I'm a bit two sides to this issue. In the Netherlands, this is a huge issue, really a huge issue, especially in the military and the armed forces. And I think, and I agree with the captain there, the military aspect is somewhat underexposed here. You spoke a lot about IHL, etc., but the problem really is, how do you train? How do you prepare for an operation? In the context of cyber, most cyber operations are below the threshold. The IHL does not apply to that situation. So, yes, when we have the IHL, when we have an operation, Chapter 7, etc., then it's all fairly clear. But how about training? How about preparing for? Our situation, Sebastian, is similar to Germany. We have a specific Netherlands-Dutch law, the Implementation Act, which says there are 2 exemptions in the GDPR. That's fine. They don't apply to us. We revoke them. So the armed forces need to comply with the GDPR, period.
Great.
Also outside of EU law. So when the military army goes to Mali, we need to comply in full with the GDPR. There's an exemption to the exemption where our minister may say, no, wait a minute, this is a specific situation. I have the discretionary authority to say, in this case, you don't have to apply to it. And the second one is we have a National Intelligence Act. If it falls under the Intelligence Act, then it does apply. So the question from me to you is, do you have any advice on how we can train, how we can create a level of readiness to prepare for activities during an operation? How to process data. An anecdote, if I, as a full colonel in the Netherlands, if I type what is the name of the president of Russia, and I get a name, and I process it in my computer, that's against the law.
That's very interesting. I think it's time for a disclosure that I wrote my article with 2 of your countrymen together, right? So this is how I came up to that information. But I think the answer is pretty simple. Even if we're operating under the threshold of IHL, which is most of the conflicts we have around the world, then we can just train the people of applying general international law. Human rights law, as we understand, incorporates provisions pertaining to data protection and the rights to privacy. And if we talk about tailor-made military training, for example, for European Union missions, well, most of them anyway operate under the threshold you just mentioned, then that would be even better to either have this kind of decision that we are asking for in our article, or to use the reasonings and rationales behind GDPR anyway, because as we understood, as Asaf mentioned, even provisions very, very old, they have the same kind of rationality, the kind of principles Eduardo put out here. They're, let's say, like pretty much universal. Even if we look at, Deborah said, like, I don't know, I forgot the number, how many different legal data protection regimes, they're all more or less similar. So I think that's a great starting point to start training and exercising and making people aware that these things need to be considered. And this is basically what we're trying to do at CCDCOE. Not shy away from this kind of unclear legal questions, but put something out there and said at least something to consider, right? So you heard about this when the real case comes around.
So can I push back on that? I'm going to. We're sitting in a room in smack dab at the middle of GDPR home ground. There's a big world out there, and in the immediate context of the tens of countries surrounding this room, people know what the GDPR is. They're acquainted with it. It is, in fact, the gold standard. Outside of that circle, it's a whole different context. And I'm not an expert in Chinese law by any stretch of the imagination, but I've read the Chinese data protection law, which has really done a cut and paste of a lot of GDPR protections that we're familiar with, the right to have information corrected and to know that there's algorithms working behind the scenes. So in the Chinese English translation of the Chinese data protection law, same list. The legal regime backing behind that same list is obviously a very, very different legal regime underlying privacy protections. My point is just that my sense is that we need to be much more sensitive and aware of the fact that there is not a vanilla flavored GDPR. I'm an admirer of the GDPR. I think it's elegant regulation. It's certainly not the global standard. And as military operations, or even militaries that encounter each other in the field of combat, need to take into account each other's regimes. I would really encourage us to open our eyes. And I'm also at fault. I think that just the assumption that there are basics of data protection that are adopted by national laws is not going to get us as far as we think it will. So that would be my pushback.
Well, I have to say I was not planning on training with the Chinese, So I was pertaining to many other countries,
I don't know why not. I don't know why not. Sebastian,
Chinese are not my area of expertise.
Third of the world.
But the thing is, definitely looking at some of the internal data protection regulation putting out there by international organizations, they have been modeled after the GDPR with the idea, hey, then at least we can get rid of that legal obstacles. So I guess we should never prepare for the panel beforehand. So we have not so much for putting back again. But
no, this is the good part. But
I stand with my opinion. So let's say like this.
Okay, blood on the floor.
Can I say very briefly? I mean, the question you're asking is a question I've been here for nearly 30 years, in the sense that it's a question of how do I comply? Who do I prepare for compliance? And before the GDPR, we had all the laws. And I think, irrespective of size, irrespective of framework in a way, it's a three-step process, as I see it. One is to identify the priorities. So of all the legal obligations that may apply to you, and the GDPR, if you count all the possible legal obligations under the GDPR, there are about 40, 45. Okay, of those 45, what are the top 3? What are the top 5? And identify the priorities. Second step, have a plan. How do you address those priorities? And that plan is going to look like, well, we need a policy for this, we need a protocol for that, we need to deploy a contract that will cover this, a security measure for that. So that's a plan. And then the third thing, which I think is very much, you already have it in your head, is creating some kind of awareness strategy amongst those people within your organization that are going to be using this information. Because ultimately, and this will be very familiar to all of you involved in cybersecurity, the human factor is in a sense the weakest link. You can have all the perfect policies, the perfect contracts, but the awareness of the individuals that are in contact with that information is critical. And therefore, those three elements, the priorities, the plan, and the awareness, are essentially the building blocks of what a compliance program will look like.
We are exactly at 3 minutes. We'll do a really fast question. There we go.
Okay, so I should have given the caveat earlier. Not a lawyer. I'm coming from the technical or operational background. So I'd like to ask, what happens when human rights principles are brought into tension? So we've thought about, securing or protecting individual soldiers' privacy in an operational context. And an example would be like technically interdicting third-party tracking on networks that we own. And one of the pushbacks that we got from lawyers was, well, that implicates free speech, access to data, these kinds of other principles. So it's not so easy to say that like, well, this is all unmitigated good. In some cases, these principles are brought into tension. So I was wondering if you could maybe address that or get your thoughts. Thanks.
In 2 minutes and 20 seconds.
I'll be really quick. You guys need to be in touch with Meta and its internal advisory board. They've got it covered. All these conflicts, and no, it's incredibly complex, and good for your lawyers for having noted it. We don't know yet. We don't know yet. Decisions need to be made.
The one thing I would add, though, is that IHL, by design, was meant in part to engage in some of these balancing acts. And so military necessity, security, operational necessities, vis-a-vis humanitarian considerations, human rights to the extent that they apply. I think that there's partially why we're having the book, why we're having these discussions, is because we haven't had all these people come together and start a conversation together. Technologies, data protection officers, IHL professionals, intelligence professionals. And I think that what you're seeing is that when we come in a room together and start having these conversations, we often just introduce a lot more complexity. But that's part of the fun, in a way. All right, that is my cue to end. So we're going to first please join in congratulating this amazing panel that we just witnessed.